Hey guys, welcome to Manoeuvre. I'm Advocate Nisha Lotia, and my today's session is for those who are confused to choose the correct mentorship, or for the ones who keeps wondering whether the content is appropriate or enough for the law entrance exam. Guys, this video will not only give you an idea about Manoeuvre's ways of teachings, but will also help you to guide towards the perfect and accurate way of preparing yourself for the most unpredictable entrance exam. But before getting started, let me tell you that Manoeuvre offers the entire online course, guys. We have the live uh, classroom lectures, we have ebooks, we have the shortcut techniques, which is very important for your time constraint exams. We have the doubt sessions, without which you cannot, if your concept is not 100% clear, it is very difficult to attempt the MCQ type of questions. Next, we have the recorded videos. So in case if you miss any of the lectures, you can hear to the mentor later on. We have topic test and the mock test, which is most crucial and important part of any strategy, any preparation. And we have the WhatsApp groups, which will keep you going, which will keep you motivated. And we have 1,000+ questions, which is very much required. अगर आपका GK है, current affairs है, all those types of things requires lots of exposure to different types of questions. And moreover, we have a correct mentorship, guys. We have the correct and the perfect mentorship. Our mentors appear exams every year. Okay, they appear exams every year, whereby they know what types of questions you'll be encountering on your D-Day and have to actually prepare the correct content to make you guys study for the entire syllabus. Okay, so what are you waiting for, guys? Whether you want to appear for MH Law, CET, Clat, Slat, AILET, BHU, Law, LSET, or any other entrance exam, guys, just book your seat with us and get tension free. 8828581454. This is the number you need to call up, or just visit us on www.manoeuvre.edu.com law entrance. Okay, the link for the same has also been mentioned in the description. Now, as I told you, that this video will not only help you to understand what is the correct mentorship, but will also give you a guide that whatever you are studying is a correct way of studying or not. These are the definitions I have taken about the Indian Penal Code, guys, which is about the offenses. The Indian Penal Code is all about offenses. If every offense, is, at the end of the day is wrong, then why are all the offenses defined? Okay. And for a layman, if every offense is a chori, but for a lawyer, every offense has been defined. The main reason why all the offenses are defined is for the quantum of the punishment. Is for the quantum of the punishment, guys. If a person is an habitual offender, okay, and if the person who has committed the first time, he might have committed first time some certain robbery, then can we both, given the same punishment? No. The quantum, that is the amount of punishment, will vary from case to case. Okay, and for that reason, the offenses, each and every offense has been defined in the books of Indian Penal Code. Here I have taken some of the offenses to explain you. Thereafter we have taken a couple of the principal facts questions, which where you need to apply these offenses. And this is how it maneuver we cover the entire syllabus, guys. We give you so many proper content, and then we practice so many questions, which is very important for the application of that knowledge. Okay, the first offense over here, what I'm going to discuss with you today, is the theft. Theft is committed when a person's property is taken without his consent by someone. Now, this is the exact definition of a चोरी. Okay, अपन चोरी किसको बोलेंगे? अगर आपकी कोई चीज है, आपके पास से कोई आपकी चीज कोई आपकी परमिशन के बगैर ले लेगा, तो उसको चोरी बोलेंगे. Correct? So, section 378, okay, of IPC, that is your Indian Penal Code, defines theft as follows: whoever intending to take dishonestly, okay, whoever is intending to take dishonestly any movable property out of possession of any person with, without that person's consent, moves that property in order to take such, in order to such taking, is said to commit theft. Now, it is about the, when you're taking somebody's property out of that person's, possession without that person's consent, then it will be said to be theft. Now, there are various aspects to it. Okay, just say if even you are severing, okay, you are severing the property which is attached to the earth. Now, for example, the trees. trees are attached to the other. The minute you cut down the trees, the minute you sever it from the trees, okay, the minute you cut it, whether you actually take it or not, you have committed the theft. Okay, now if there is a thief at your place, okay, he's trying to rob something, but before he could actually take away that stuff, say maybe he's come and he wants to rob your TV, okay, he could actually practically take away that TV. He has just moved out from there. Okay, he's just taken a TV out of the connection, and he was just moved out from there. The minute he has just severed this tree from the wall, it means that he has committed theft. Whether he actually takes it or not is not the court's purview. Okay, only if even he has just moved a thing out of there will be said to be theft. Okay, now I've taken a couple of illustrations which will help you understand it in a better way. A finds a ring belonging to Z on a table in the house of Z. Okay, now it is the Z's property. Okay, that is a ring which is in his house. Here the ring is in Z's possession, correct? And if A dishonestly removes it, A commits theft. Okay, now if he is gone there, maybe he's a laundryman or maybe he's an invitee over there. A can be any person, correct? Practically, he or she can be any person. Now, if A takes the ring out of Z's possession from there, then A commits theft. Correct? This is a simple example to explain you theft. If A owes money to Z for repairing the watch, this is a very interesting example, students, please pay attention. And if Z retains the watch lawfully as a security for the debt and A takes the watch out of Z's possession, now A owes money to Z for repairing the watch. अगर आपने आपकी watch repairing के लिए दी है तो you have to pay the service charges for that, correct? Without paying the service charges, how can that person release the watch, correct? So no doubt यहाँ पे A की watch है, the ownership is of A, correct? The ownership is of A. So if now Mr. A takes out the watch out of Z's possession without Z's consent, even if A owner है, then also if he is taking out that watch without Z's consent, he will be said to commit theft. This is lawfully allowed now, guys. If A owes money to Z for repairing the watch, and if Z retains the watch lawfully as a security for debt, and A takes the watch out of Z's possession with the intention of depriving Z of the property as a security for his debt, he commits theft in as much as he takes it dishonestly. Okay, because he has taken this watch dishonestly. He was not supposed to do this. Whatever his intentions were not clean intentions, guys. His intentions were malefied intentions. Okay, so here theft is regarding the possession and not the ownership. Am I clear about it? So whenever there is, you feel that the definition is so easy, but there are so many aspects to it which has to be clear in your mind. And एग्जाम में जो आपके प्रिंसिपल एंड फैक्ट्स आते हैं ना वो इसी पे बेस्ड होते हैं. ओके, सो दिस इज थेफ्ट व्हिच इज आई विल पुट इट एज अ नॉर्मल चोरी. नाउ देयर इज समथिंग व्हिच इज कॉल्ड एज रॉबरी. फॉर अ लेमैन, guys, for a layman, theft, robbery, dacoity, extortion, everything is a chori. Huh? ये कुछ भी हुआ ना, but they will name it as a chori only. But all these four definitions are very much different in the eyes of law. So let's look at robbery. Theft is robbery if in order to committing of the theft or in committing the theft or in carrying away or attempting to carry away property obtained by the theft, the offender for that end voluntarily causes or attempts to cause to any person or wrongful hurt or restraint or fear of instant death or of instant hurt or of instant wrongful restraint. Now guys, I'll give you a simple example. Okay, if Mr. A, if Mr. A is the employee in an office, okay, he's an employee in an office. Okay, now if Mr. A is allowed, as if he being an employee, he is allowed to go anywhere in the office, correct? So now if he is trying to take away Mr. X's computer, okay, so Mr. X is not available at his desk, so he will just, what will happen, he will just go to his desk and he will just pick up the computer and walk away. Okay, so there is a plain theft. Okay, there is a plain theft over here. Okay, plain theft. But now Mr. Y, who is sitting next to Mr. X's cabin, is watching all this, and Mr. Y is questioning that to Mr. A, that why are you taking his laptop? What is it that you wanted? Correct. Wait for Mr. X, let him come. So now Mr. A knows that Mr. Y has some doubt regarding this computer. So what he'll do? He will put him in a wrongful restraint. What does the word restraint mean? वो उसको रोकेगा. Okay, he might have lock him in a room, or he might create some hurdle, or he might he might give him an instant hurt. That is, he might give him a blow, he might give him a punch. So there is there is some physical assault or physical attempt of some extra thing. Okay, so whenever you're putting that person into the physical harm or physical restraint, then it is not a theft, then it is an extravagant form of theft, that is your robbery. Okay, अगर वो सिर्फ प्लेन उठा के मिस्टर एक्स का कंप्यूटर निकल जाता है, कोई उसको रोकता नहीं, कुछ भी नहीं, then it is a plain theft. Why? Because the definition says that you are taking away the property out of somebody's possession without his consent. Correct. But the minute you're using the force, guys, the minute that you're using the force, then it will be robbery. It will be robbery. Okay, the example will make it more clear. For example, if A holds B down, okay, if A holds B down and fraudulently takes B's money from B's purse without B's consent, okay, here, A has committed theft, and by committing theft, he has voluntarily caused restraint to B. Therefore, A has committed robbery. Okay, A has finally committed robbery. It is not a plain theft, guys. It is a robbery because he holds him down. Okay, there is some force being applied. There is some force being applied. ऐसा नहीं कि चुपचाप कुछ लेके निकल गए. Okay, जैसे if you're going by in the train, correct, and कोई पीछे से आपका पर्स ले लेता है, so that is pure theft. Okay, that is pure theft. But over here, अगर वो पर्स आपके पर्स में से जेब में से पर्स निकालता है, and if you find that something is moving out of your body, so what happens? You hold his hand. Correct, you hold his hand and you try that he shouldn't take away that thing. So आप दोनों के बीच में अगर कुछ मार पिटाई होती है, या he will just give you a blow, और वो आपको push करेगा, then it will be a robbery. It is not a plain theft. Okay, it will be the case of a robbery. Okay, so this is how a theft is different from a robbery. Now, if you see in this slide, I have explained extortion. Extortion is nothing but when you're causing fear. When you're causing fear, and thereby the person who जो डरा हुआ person है, he is induced to give you away his valuable things, money or whatever it is, the valuable things, then it will be called extortion. Okay, whoever intentionally puts any person in fear of injury to that person or to any other, मतलब आपका कोई फैमिली मेंबर हो गया, आपका कोई नियर एंड डियर फ्रेंड हो गया, anybody, okay, if anybody, and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security. Okay, so it is about movable and immovable, both. Okay, it includes both, guys. Correct? Or anything signed or sealed which may be converted into valuable security commits extortion. Okay, he or she commits extortion, guys. When that person puts you in the fear of death or a grievous hurt or a simple hurt, okay, so that person, and thereby you are induced because of this fear, then it is called extortion. देखो, robbery में ना कोई fear नहीं है, direct force है. ओके, डायरेक्ट फोर्स है, वो आपको धमकी नहीं दे रहा है कि मैं तेरे को मार दूंगा, वहां पे फोर्स ऑलरेडी अप्लाई हो चुका है. ओके, दैट पर्सन हैज अप्लाइड फोर्स इन सम form or the other. Correct, maybe that is a blow, maybe that is a wrongful restraint, maybe that is a hurt. Correct, but यहाँ पे extortion में he is not harming you. As of now he is not harmed you. Correct, he is just showing you, he is just causing an apprehension, he is just causing an fear. Okay, जैसे यहाँ पे देखो ये पिक में दिखाया है, he is showing you the gun, and thereby you are giving him the money. Correct, so there is a kind of a fear. Correct, for example, if A who kidnapped B's child Z, okay, A who kidnapped B's child Z demands a sum of rupees 10 lakhs from B. Okay, all the efforts made by B in order to know whereabouts of his child turned out to be futile. Futile means matlab it is of no use. Okay, because he did not find the child. Correct, B with all the failed attempts paid the prescribed amount to A. A has committed the offense of extortion. A has committed by he has put the fear of the child in the mind of the father. Correct. So over here, this is a pure case of extortion. You see, there is no direct force applied. Okay, there is a fear used. And in robbery, there is a force applied. And in theft, guys, there is no force, no fear. just उसने चीज ले ली है, okay, out of your possession, okay, and that is without your consent, and that is a dishonest thing, correct? Did you understand? Now dacoity is altogether a different thing. Now when five or more than five conjointly commit or attempt to commit a robbery, or where the whole number of persons conjointly committing or attempting to commit a robbery and persons present and aiding such commission or attempt about to five or more, every person so committing, attempting or aiding is said to commit dacoity. Now dacoity is nothing, okay? It can be, it can be robbery, it can be your extortion, but then what is it? That there has to be five or more than 5%. If it is not proved, guys, if it is not proved that there were 5%, then you cannot be charged for dacoity. Okay, there has to be, five, minimum five, yeah, more than five. Okay, now this is the case law, very, very interesting case law, guys. Please pay attention to this. Ram Shankar Singh versus State of Uttar Pradesh, AIR 1956, SC 441. Now, what is this, guys? This is All India Reporter. एक book होता है, okay? उसमें, when you go to page number 441, it is a Supreme Court case which was decided in 1956. Okay, so this is इसको बोलेंगे case law. Okay, this is said to be a case law. Very, very interesting it is. The facts are six persons were charged with committing dacoity. Three out of the six were acquitted, means they were set free. Okay. The charges framed did not indicate that along the six persons there were other unknown persons with them who had committed dacoity. Okay. So in all, they were when the charge sheet might have filed, there were only six persons. Since three persons were acquitted, means that उसमें से since three persons were acquitted, मतलब छह में से तीन को आपने free कर दिया है. Now there were only three persons left. Okay. Now the question is, with the three persons left, can the offense of dacoity be proved? Okay. So let's see what is it. What is the judge saying us? There were only three other persons left as the persons involved with the crime. Hence, it was held. Whenever the word held is there, it is said that it is a judgment of the honorable court. Over here, it is the Supreme Court. Okay, so it was held that the three persons could be convicted only to the lesser offense of robbery under the section of 392 of IPC and not for dacoity. Okay, they can be held only for robbery. Okay, they were doing. Of course, they have committed offense. Correct. They are charged of offense, but not of dacoity, guys. Not of dacoity. They will be, held only for robbery. Okay, robbery is a lesser form of punishment than dacoity. Am I clear about it? So it is very clear that you need five or more persons. So this is the way how you have to apply the given, principle to the facts in your examination. For this reason, it has to be very much clear in your mind ki what are the essentials of each and every offense. हर एक के essentials आपको, हर एक के essential ingredients, हर एक के essential elements आपको पता होना चाहिए. जैसे कि dacoity है, there has to be minimum 5 people. For extortion, there has to be a fear. For robbery, there has to be a force. For theft, there has to be, movement of the property without the consent. Correct? So these are certain things which is very, very important, and then only you can come to the correct answer in your given examinations. Now, here I have taken a principal fact situation which you face when you in examination, the same pattern. Okay. The question one over here, the principle says theft is robbery. Okay. If in order to committing of the theft, or in committing the theft, or in carrying away or attempting to carry away property obtained by theft, the offender for that end voluntarily causes or attempt to cause any person death or hurt of or fear of instant death or instant hurt. Okay. Now over here, when you see a principle is nothing, guys. Principle in the examinations will be nothing but your definition plus certain condition. That's it. The minute you know it is about theft, you need to never reread the definition in the examination. That will take away the time because it is a legal language and you are not used to. Okay, so the condition has to be very much clear and the concept has to be very much clear. Okay, what is a theft? What is a robbery? What is an extortion? What is a dacoity? For that matter, there are so many other offenses which are into the same lines. There's a criminal breach of trust. What is a criminal misappropriation? What is a burglary? all these offenses, at the end of the day, they are wrongs, but all have been defined to just to know the quantum of the punishment. Okay, so let's see the factual situation over here. A entered B's house to take away her TV. When he was carrying the TV out of the house, he encountered B near the door. He left the TV behind and ran away. Okay, he when he was carrying the TV, मतलब उसने TV का position change कर लिया है. Okay, he has took the TV, but he could not take it away. Why? Because he left the TV behind and ran away. So what are the four options? A has committed theft, A has committed robbery, A has committed both theft and robbery, A has neither committed theft nor robbery. Now, A has neither committed theft nor robbery could not be the answer because there is an offense. He has done some wrongful movement. A has committed both theft and robbery. For the theft, what is the definition saying? There has to be movement without the consent. Correct? And for the robbery, what is the definition saying? There has to be force implied or there has to be a wrongful restraint. But any of these things are not, we cannot see all of these things for the which is required for robbery in the factual situation. We see a plain theft, guys. We see just the plain theft, okay? Because there is no force applied. A entered B's house to take away her TV. When he was carrying the TV out of the house, he encountered B near the door. The minute he is seeing B near the door, he is not, giving him any blow. Correct? He is not, locking him up in his own house and, running away. He is doing nothing. He is just leaving the TV behind and he is running away. No doubt he could not take the TV, but yet the offense will be of theft. The offense will be of theft. So A is the correct choice. There cannot be robbery. There cannot be robbery in this case because there is no force used. Correct? So this is the way you need to apply the given, concept to the principal fact situation. In the examination, students, if you read the entire principle properly, understand it, then you read the factual situations, and when you mark the correct answer, then only you fetch 1 mark. Okay, so time is very, very important. It can be time consuming if you don't know the concept, if you are not used to this kind of reading. So at Manoeuvre, we make sure that students do lots of questions with the professors or with the lecturers, and then after they apply mocks, okay, they appear mocks and they analyze it, whereby during the examinations the reading goes very smoothly. Okay, let's see one more example. The principle says whoever intentionally puts any fear in whoever intentionally puts any person in fear of any injury to that person or to any other and thereby dishonestly induces that person so put in fear to deliver to any person any property commits extortion. Okay, so here there is a case of fear. Okay, the main ingredient in extortion is the fear. And ये fear की वजह से आपको कोई कुछ दे रहा है, then it will be called as extortion. It will be called as extortion. Factual situation says A entered B's house, caught hold of B's daughter. Okay, now it can be fear can be for what, for that person or any other person. So any other person में आपका B's daughter can be included. Correct? C. Whose B's daughter is C. And threatened to stab her if A did not give him rupees 10,000 immediately. B did so. Correct? B did so. Why did B do it? Because of the fear caused. है ना? ये fear की वजह से he was induced to do it. Correct? A is prosecuted for extortion. Now, okay, is this possible? What if A is prosecuted for extortion? Will this be eligible or not? Let's see. A has committed theft, not extortion. A has committed extortion. A has committed both theft and extortion. A has not committed any offense. Okay. Here it is not about theft, guys. It is not about theft. Why? Because वो खुद अपने आप से पैसा दे रहा है, तो consent की तो कहीं बात ही नहीं आ रही है. Correct? Consent is there, but there is an not a willful consent, but whatever the consent is present, so it cannot be theft. Okay, A has committed theft, not extortion. It cannot be theft over here because consent की तो कुछ बात ही नहीं है. A has committed extortion. This looks good to me, but yet I'll read both the options. A has committed both theft and extortion. No, this is also not there. A has not committed any offense. See, this is can never be the answer. Correct? So B, A has committed extortion is the correct answer choice. So guys, we here at Manoeuvre, we first make you understand the concepts. correct? Afterwards, the second step is that we make you solve questions with us only. Okay, the practical principle facts questions, the assertion reasons questions, and the third step is we have an entire mock which you need to appear and upload, correct? And then the fourth is that you have to analyze it, and you will see after each mock कैसे आपके marks बढ़ रहे हैं. You will see how it is helping you, correct? So this is a pattern what is followed by Manoeuvre, and I feel this is one of the best patterns which you need to follow when it comes to the entrance exam, whereby we cover the entire syllabus. Guys, once again, I'm repeating, we have the live lectures and we have the books, we have the mocks, okay? We have the entire process which is required. And you can, join us on our YouTube channel. Do subscribe and do like this video, so, it will help me to make another video of the same kind. Okay, you can, follow us on Facebook. You can follow us on Instagram also, where we have lots of, syllogisms and vocabulary and so many things going on. You can join us at our a Telegram channel also, guys. So check the link in the description and do join Manoeuvre, which will really help you in your preparations. All the best and stay safe. Thank you.